with us the usual gang comprised of Mr. Rushongoza, Begumya, Lorika. I don't know how he got the Lorika name. We'll try and ask that much later. I have Mr. Alfred Muyaaka seated right across from me, and we have Mercy, who is also joining us online. We will try and have as many conversations as possible, as many questions, but more particularly today's space is dedicated to understanding South Africa's experience with mission-based judges or acting judges. And to guide us into that conversation, of course, we have none other than Mr. Mbekezeli Banjamin. I do not know how to start introducing Mr. Mbekezeli Banjamin, but I think top of mind to start with is that in 2023, Mr. Mbekezeli was amongst the top 200 young South Africans. He's one of the leading experts on the judiciary in South Africa. He's a contributing author to the Judicial Financial Independence in Africa, and currently the lead author, Judicial Chapter of South African Constitutional Law. Mr. Mbekezeli has a background in human rights litigation, research and advocacy, and he holds an LLB from the Wits University and is currently doing an LLM at Constitutional and Administrative Law at the University of Cape Town. Mr. Mbekezeli, we're very glad, very delighted to have you, and we look forward to this conversation. We've been revolutionary for the most part of our spaces every Wednesday, and of course nobody can stop reggae. And I am delighted now to first of all invite Mr. Elison Karuhanga to start us off. Elison, do you want to come in now?
Thank you very much, Raymond. And Benjamin, thank you so much for joining. And I see we've been joined by a number of interesting people, not least of whom is the president of the Uganda Law Society, Mr. Isaac Semakade. Greetings to you, salutations to you from all of us here. I think this is an important conversation for us to have about mission-based judges. But Benjamin, maybe before we get into this important conversation, we could ask you to tell us something about Benjamin. We've had the profile, your legal research and advocacy officer at Judges Matter, which is one of the leading think tanks in Africa on the judiciary. You've written, I think, as a contributing author to one of the only books about financial independence in the judiciary. You've been highly regarded. I think you lecture at Stanford University. You're like a big small corner of Soweto called Zondi. Soweto is obviously one of South Africa's biggest townships. I think it is the biggest township in South Africa. And historically, townships were one of those underdeveloped areas of cities in South Africa. And so understanding injustice from that perspective, of course, the apartheid legacy in South Africa also colored those motivations for pursuing justice in South Africa.
And so understanding injustice from that perspective, of course, the apartheid legacy in South Africa also colored those motivations for pursuing justice. And so when I finished my schooling, I went to law school at Wits University in Johannesburg, and that's where I did my law degree. And for a while, law didn't make sense until I met one of our lecturers who was a human rights lawyer, and he taught us law in a way that made sense in the world, in that you're not just doing law for the sake of doing law, but really to pursue justice and transform society for the better. And that's how my journey started. So I started off in human rights law, focused on the right to housing primarily, later on the right to education, and the right to protest in particular, because protest is one of those potent rights that in South Africa historically has been used to achieve change, social change. And so I was really motivated to protect and advance that right. And then later on, I was quite curious about the role and impact of judges because, as you would know, South Africa after apartheid in '94, we adopted a new constitution which had a Bill of Rights and included socio-economic rights, and so judges played quite a central role in making sure that the constitution is made real, and so that's how I started to think about the role of judges, and since 2020, I think formally, I've worked at Judges Matter, which is a think tank that is based at the University of Cape Town. And our mission really is to ensure that we have the very best judges in our courts and holding them accountable to
much,
the high
Benjamin.
standards of our
Good to hear
constitution. So that is
everything you've said.
broadly
We have
where
colleagues
I
of the
come from,
University
and that's what
of Cape
drove
Town.
me
I
to
know
do the
Professor
kind of work
John
that I
Dembele,
currently do.
who actually introduced me to Benjamin. We have Hanad Nabagala there as well.
Thank you so much,
He's a
Benjamin.
fantastic Ugandan
It's good to
community
hear
there, and I'm sure they are
everything
all
you've
joining
said.
in and are going to be very happy. Maybe before we dig deep into this, maybe if you could also just tell us very briefly about the University of Cape Town and Judges Matter. What is Judges Matter about? Because I can tell you where we are sitting, judges really matter.
Yeah, unfortunately, judges do matter to our lives, particularly in any country that aims to be a vibrant democracy that upholds
Judges really
the rule of
matter.
law. Judges play a central role. Yeah, unfortunately, judges do matter to our lives, and particularly in any country that aims to be a vibrant democracy that upholds the rule of law. Judges play a central role, and in fact, in the news right now, you hear the President of the United States attacking judges, and it's not by mistake. It's because judges are supposed to constrain even the most powerful politicians, so for them to comply with the law. And so, judges do matter in that context, but they also matter for us in Africa generally, not just in Uganda or in South Africa. But Judges Matter's mission is very simple. Ours is to see a vibrant democracy under the rule of law, and that is underpinned by an adherence to the Constitution, to human rights, and to creating spaces where we can achieve social justice in our country. And so Judges Matter's mission is to ensure that we play a role in ensuring that the very best lawyers become judges in our courts. And once they become judges, they need to uphold the highest standards of judicial excellence and ethics, and also that the administration of the judiciary or the governance of the judiciary ensures excellence, independence, and integrity. So that is our core mission, and we are primarily a research-based organization. So we are based in the law faculty at the University of Cape Town, and so we are primarily researchers, academic researchers. All of us are lawyers for all our sins. We became lawyers, and so we do research, but the research is supposed to, it's not just academic research in an ivory tower. Our mission is to ensure that the research finds application in law, in policy and practice. And so we spend a lot of time looking at the judiciary as an institution and finding ways in which we can promote reforms that achieve our mission of a strong, independent, robust judiciary that is able to achieve the lofty ideals of the Constitution. And so we spend a lot of time looking at how judges and magistrates are appointed. So every single year I attend dozens of judges' interviews. We write up about that. We try to make it relevant to ordinary people. So we do speak a lot in public about the role of judges and how they are appointed. And also we look at how the system to hold judges accountable also functions well. So we do a lot of research on that. And then you mentioned earlier that we were contributing authors to a book that looks at the financing of judiciaries in Africa. And in fact, we did the chapter that focused on South Africa, but in that book, there's also a chapter on Uganda, on Kenya, on Malawi, Zimbabwe, and 11 other African jurisdictions. And we were trying to understand how the financing and
Thank you very
resources of
much,
judiciaries actually
Benjamin. I
impact
think
on their independence,
really
but primarily on their
ties us
functions
into the
and
conversation
ensuring
we'll
that
have
they
today.
deliver justice to ordinary
In
people in
Uganda right
Africa.
now, we are in the middle of very many things, as very many people know. But one of the fundamental discussions we are having is about the sort of justice system that we are delivering. Our constitution provides, within Article 142.2 of it, that where the state of business in the courts of judicature requires, the president may, acting on the advice of the Judicial Service Commission, appoint people to act as judges. And we have coined the term mission-based judges. We are saying that the constitutional jurisprudence in Uganda allows for judges to carry out a mission, for lawyers to be appointed as judges on a mission to get in and clear things like backlog. And we have a real serious backlog problem. At the moment, about 45 trillion shillings, which is about, I don't know how much that is in dollars, give or take a good number of dollars. About 45 trillion shillings is held up in litigation in the commercial court alone. We are looking at remand times for people on remand. Some people are on remand awaiting a criminal trial for more than 5 years, in some cases 7 years. We have an average time which a land dispute takes resolved being 5 to 10 years. We have 12,000 appeals currently sitting at the Court of Appeal. We have judges on dockets of 1,000 cases each. So our contention is that at the moment, the men and women who serve in the Ugandan judiciary are overburdened with work. And yet there is a solution. The solution is called the Uganda Law Society. It's called the members of the bar, in the large numbers who can come in and help clear the backlog. And so today's conversation is really going to focus around the South African experience of using lawyers in an ad hoc capacity to come in and help the judiciary, to help carry the weight and then go back into practice. And I want to just hand over at this point to Rusho, Mr. Rushongoza. Maybe he can take the conversation forward. But Benjamin, that really is the context within which we wanted to have this conversation, to learn about what's happening in South Africa.
Thank you, Rusho.
Mr. Rushongoza, maybe he can take the conversation forward. But Benjamin, that really is the context within which we wanted to have this conversation, to learn about
performance
what's
reports that for the South African judiciary that Judges Matter has put up, and you see consistent shading of backlog, 27% one year, 47% in criminal cases another year, and so on and so forth. And yet, last year, maybe two weeks ago, we said here that the interventions of the Ugandan judiciary alone had shed 0.1% of the backlog. So the numbers, Benjamin, you are probably doing in backlog are nowhere compared to any of our numbers. In fact, by comparative terms, the total caseload of the Ugandan courts a year would, if I converted them into people, would fill the FNB stadium 4 or 5 times. And yet we have 700 judges for all of that. So then the conversation or the focus of intervention became this idea of using judges to resolve backlogs or to resolve specific objectives. I wanted to hear how you are using acting judges in South Africa, how they are working, and maybe we start there. What is this thing called an acting judge? What does it do? How different is it from, your conventional quote-unquote judge?
We start with just a broad explanation of the South African court system, right? At the lowest level, we have what are called district magistrates courts.
So I think it might be easier if we start with just a broad explanation of the South African court system, right?
They have both civil and criminal
At the
jurisdiction.
lowest level, we have what are called district magistrates courts. And those are usually courts that are based in a smaller area of the country, and they have both civil and criminal jurisdiction. So for criminal jurisdiction, they would deal with cases like assault, robberies, housebreaking, and the like. And then their civil jurisdiction is up to a monetary limit of 200,000 rands, which is about $11,000 roughly. And then at the next level, we have regional courts, which cover a much wider area, but it's still in the magistrates' court, similar to what the magistrates' courts that you might have in Uganda. And those regional courts would have in civil cases, they have a monetary jurisdiction of about 400,000 rand, which is give or take 22,000 US dollars. And then at that next level, we have the High Court. And in South Africa, we have a unified High Court system, and then it has a divisions in each of the 9 provinces of South Africa. So each province has a High Court division. So Gauteng, Eastern Cape, Western Cape, each have a High Court division. And at that High Court division, you have a different centers. I'll call them centers. So, for example, if you go to the Gauteng division of the High Court, there is a center in Pretoria and another center in Johannesburg. And in each of those centers, there are judges stationed there, right? So that's just broadly the system. And there are obviously other courts above those, including the Supreme Court of Appeal, which deals with all appeals from all the high courts in the country, and then the apex court is the Constitutional Court, which deals with appeals from the Supreme Court of Appeal. So I'll exclude the appellate courts for now. I'll focus primarily on the high courts, which will make our conversation easier, because the magistrates court, we do have magistrates there, but I'll exclude them for now. The focus is on the high court divisions in each of the 9 provinces. And then I mentioned that each division has different centers. So we have about 20 high court centers across South Africa, and each of those centers, they have judges stationed there, including acting judges. Now, another thing that I need to also explain is this. I'll use acting judges. I know in Uganda it's quite controversial to refer to acting judges because of I think it's the Kubamba case. So you'll please forgive me for using that term, but that is the term that we usually use. And maybe in Uganda we will try to use Elison's term of mission-based judges, but we are trying to refer to a similar concept. So in South Africa, we have acting judges, and we've had the concept of acting judges for many years. It's a tradition that we inherited from the British legal tradition that also exists in Uganda. But what happened in 1994 is that it was codified in the Constitution in Section 175 of the South African Constitution, and in that section allows the Minister of Justice to appoint judges as acting judges to the different high court divisions and at the different centers. And the minister does have an appointment power, but really the power broker is the judge president of each division. So the judge president would usually be the one who will recruit acting judges, and they will recommend to the minister that these are the people that I want to appoint at a specific center for this period of time, and then the minister would often sign off on that appointment. It's hardly ever, I don't know, to my knowledge, any instance where the minister refused to appoint an acting judge based on the recommendation of the judge president. And again, I should explain here that unlike the Ugandan constitution, so if you read Section 1 or Article 142 subsection 2 of the Ugandan constitution, the appointment of mission-based judges or acting judges is done by the president of Uganda in consultation with the Judicial Service Commission. In South Africa, we exclude the Judicial Service Commission when it comes to the appointment of acting judges. So that's just plainly the process. And what are acting judges meant to do? Usually they will be appointed when there is either a casual vacancy that arises in a specific court. So, for example, judges are entitled to 3 months of long leave for 4 years of service. So if you've served for 4 years, you're entitled to 3 months off. But during those 3 months, cases need to go ahead, and so there needs to be someone who moves those cases ahead, and usually acting judges are appointed to deal with those cases. Sometimes judges fall ill, and so there will be a period of time when judges are not able to do their work, and so you appoint an acting judge to deal with that period of time when the judge has fallen ill. But there's also a period of time when judges retire, and the period of time between the retirement and when the final appointment is made, that period of time is also filled in by an acting judge. And so those are broadly why the primary reasons why acting judges are appointed. But there's also circumstances where they are special acting judges that are appointed. I'll call them that. Where, for example, when there is a very high backlog in a specific court, there will be acting judges who are appointed to deal with those specific backlogs. And those kinds of projects have been in place for many, many years. And in different parts of the country, they have employed those projects where you recruit special acting judges to deal with the backlog. Most recently in the Western Cape, there was a partnership between the Western Cape High Court and the Cape Bar to try and recruit senior advocates at the Cape Bar to assist with dealing with criminal backlogs, criminal appeals every Friday. So every Friday there will be senior advocates from the Cape Bar who will come in to adjudicate appeals, criminal appeals, in order to reduce the criminal appeal backlog. So those are some of the circumstances. But in other places like Johannesburg, which is one of the busiest high court centers in the country, they also have a general backlog in civil cases, and so they do recruit acting judges to assist with adjudicating cases in the civil courts. And again, the recruitment usually is of very senior advocates. So the requirement, even though it's not written, but in many parts of the country, there is a sort of implicit requirement that you must have a minimum of 12 years at the bar. You must have practiced for 12 years, and even the nature of your practice must have the depth and complexity to prepare you to serve as a judge of the High Court. So you can't really walk off the street and become an acting judge. So those are some of the requirements that are put in place to when it comes to the appointment of acting judges. But that is just broadly how the system works in South Africa, and has been working for at least 30 years.
You talked about the Kabumba case. So in Uganda, we have a scenario where people were appointed as acting judges, maybe for a period of 2 years, and when they finished serving those 2 years, they are then confirmed as full-time judges, and that is a dispute that was taken to court, almost like probationary judges. Did you also have a system of probation within South Africa, so that we can see? Because in Uganda, our contention has been that probationary system is not independent, and what we want to understand is that distinction between the acting judge and the probationary judge, as you have it in South Africa, and then also how widespread it is. Is it because is it very ad hoc? Is it very widespread? And then when they do come in, how they help? Also, very ad hoc. Is it very widespread? How they help?
So I spoke earlier about the magistrates' court. So yes, there was a probationary system that used to apply in the magistrates' court. So for you to be appointed as a magistrate, magistrates were recruited primarily from practicing lawyers. So either lawyers in private practice, and in South Africa we have a split profession of attorneys and advocates. So attorneys or advocates would be recruited to be magistrates, and sometimes they would be drawn from the prosecution service. So senior prosecutors would also be appointed as magistrates. And before your appointment as a magistrate was confirmed, there was a period of probation that you needed to serve. And that period, depending on the court level, would either be 3 months or 6 months. And after that period, your appointment would be confirmed. And that was a system that existed for many, many years. But it was done away with around, I think, 2000 or 2002, if I'm not mistaken. It was done away with because it was seen as an infringement of judicial independence, and which is one of the core constitutional principles protected under Chapter 8 of the South African Constitution. And the argument was that if you appoint this person for a probationary period, even if the period is 3 months or even 6 months, that person, you will be assessing them on their performance of their duties in court, obviously, or their temperament and their ability to do the work. But you'll also, in some way, even if you deny it, but you will also be looking at the kinds of judgments that this person is passing. So you will be looking at the rate of conviction or acquittal, and those unfortunately go too deep into this sacred space where judicial officers across the board, whether a magistrate or a judge, you are supposed to be protected. No one should really be interfering with your decision making. So the sense that was felt there was that you obviously would confirm after that probationary period, you will confirm, or you are more likely to confirm people with high conviction rates versus someone with lower conviction rates. That means it is an incentive for someone to find people guilty, even though the law might not necessarily, or the law and the evidence might not necessarily point towards a guilty finding. And so that probationary period was one of the key motivations for why it had to be done away with. But the second motivation, I think it might not apply so much in Uganda, but in South Africa, it was a strong motivation that the people who did the probation, who confirmed the appointment of the magistrate after the probation period, were senior magistrates. And unfortunately, the senior magistrates in South Africa were often white and male. And so there was mistrust that these people would be objective in assessing whether this person actually passes probation. There was a strong sense that their motivation would be, or there would be prejudice in how they assess it. So if you, for example, are a black woman who comes from a village and you speak English in a particular accent, you might not be confirmed versus a white person who comes from the suburbs of Cape Town who speaks the Queen's English. So there was those kinds of sentiments as well, that there would be racism in that process. And so that was another reason why this probation was done away with. But it's in some way, so it was done away with as a formal process. But I must confess that even in the process of acting judges in the high courts, often it has been used as a probationary system. It's not a formal system, but when you are appointed as an acting judge, or let me rather say, when you want to be a high court judge in South Africa, the likelihood that you will be appointed without ever having served as an acting judge are very, very slim. So you having served as an acting judge has sort of become a probationary period. But it's not to say that no one who has never been an acting judge has been refused appointment. There are people who have served as, or who have not served as acting judges, but who've been confirmed as permanent appointment judges. Usually those would be very excellent advocates or excellent lawyers who would sort of hit the ground running. But it has sort of become a requirement, even though it's an implicit requirement, it's not formally written down. It is, in my view, It has its benefits in that you do some sort of, someone gets a real understanding of how the work of a judge really is, because there are many lawyers who would be very good as legal practitioners but would be terrible as judges just because of their temperament. They just don't have the patience or the positive attitude or a manner of speaking to people that would commend them to judicial office. But at the same time, I do feel that sometimes having it as a formal requirement does impact on judicial independence. And so I'm really skeptical about the use of probation of any kind, written or unwritten, formal or informal, in the appointment of judges.
Yes, thank you, Mr. Benjamin. Now, in Uganda, acting judges have been linked to probationary judges. And it is understood that these probationary judges work in a way to please the appointing authority so that they are confirmed on a permanent basis. But as a society, we value judicial independence and zero political influence in the making of decisions. So one would wonder, or I would like to find out from you, how does South Africa safeguard judicial independence while minimizing the risk of political influence in the decision-making process by the acting judges? Thank you. Well, minimize influence process by the acting.
Thank you very much for that question. By the way, I did read that Kabamba judgment, and I do think that it was a cynical use of Article 142, subsection 2 of the Ugandan Constitution, and it needed to be struck down. That probationary system in Uganda, I do think that it was improper, and it was correct that the court struck that issue down. But to answer your question on the political influence when it comes to the appointment of judges, this is something, in fact, we at Judges Matter have been looking at for many, many years, is how do we safeguard the process of appointment to make sure that it is rigorous, that it is fair, that it makes sure that the very best lawyers become judges in our courts. And so that's been our preoccupation for the last decade or so. And how, maybe let me start by explaining how the process of appointment works in South Africa. So we have a Judicial Service Commission, and the Judicial Service Commission is made up of 23 members, and they grow up, they expand to 25 when it comes to the appointment of High Court judges. But broadly, it's about 23 members. It is chaired by the Chief Justice of South Africa, and it is made up of about 13 lawyers and judges and 10 members of parliament. And the 10 members of parliament come from both the majority party and minority parties, and they come from both houses of parliament in South Africa. And the reason why the JSC was created was because they were, in the past, before 1994, judges were basically appointed by the Minister of Justice acting alone. He could pick any advocate off the street and make them a High Court judge. And in fact, during apartheid, at some point, especially when apartheid became particularly violent and brutal, and the judiciary was complicit in that violence and brutality, including hanging of political activists, that at that point in time, the Minister of Justice was basically appointing advocates who were compliant or supportive of the apartheid system, and excluding anyone who had any questions about apartheid. And so the power of appointment was really in the hands of the Minister of Justice. And so there was this deep skepticism about this apartheid judiciary and whether it would actually be able to implement this new rights-based constitution post-apartheid. And so in 1994, they created this Judicial Service Commission, and it is quite large. It is much larger than the JSC in Uganda, which I understand is made up of about 9 members. It's also, I think, one of the largest in the world generally. But the reason why that was is because there was a feeling that you can't leave the appointment of judges only to the lawyers, because the lawyers would inevitably appoint people who think like them, and often who would be prejudiced in some ways. And so you wanted a balance between lawyers and other people, and the other people became really the politicians. But at the same time, they didn't want to leave it only to the politicians, as we see in the United States, where really, depending on which person is president, you get judges who fall in line with that person's political opinions or political views. So we also sort of didn't want that kind of politicized process. So we have a process which is fairly balanced in terms of politicians or members of parliament and lawyers and judges sit together and they decide on the appointment of judges. And the interviews to be a judge are done in public, and they are broadcast. Where in the past and before 2015, when we came into the scene, they were not broadcast publicly, and so we tried to get that broadcast running, and so it is still done now. On the 1st of April, in fact, there will be interviews for judges, and they are broadcast online on YouTube. So that process is fairly transparent. But where we did see a level of political influence of some nature was when it came to the private deliberations following the interviews. At some point in time, the Minister of Justice was a very senior member of the ruling party, and he would sort of whip the politicians into line. And so you would find a situation where the Minister of Justice, because of the clout he holds politically, he would be able to sway the JSC to vote for one or other candidate, and that person would be appointed as a judge. And so that was a big problem. And so what we have been advocating for, and based on research that we've done, we published a paper in 2021 where we showed that the JSC was actually following an unfair process, where one candidate would be subject to an interview lasting 115 minutes, another candidate would be subject to an interview that lasts 34 minutes, and there was no rational reason why there was a distinction, because if you look at all other qualities of these candidates are the same, but somehow this one is treated more harshly than the other. And so what we have been advocating for is that, firstly, there should be written criteria to guide how these interviews are done. But secondly, and more importantly, is that the people who are appointed as commissioners under JSC must be people who would be able to carry out the real mandate, the constitutional mandate of the JSC, and leave aside their political issues. And that sort of happened from about 2022, where we saw a JSC that was sort of less focused on the politics of the day and more focused on getting real people and scrutinizing them as lawyers to test their suitability for appointment. So to answer your question, sorry for that long-winded answer, but to answer your question, you can't entirely insulate the process from sort of the bigger politics of the country, but you can design the system for appointment to ensure that you eliminate as much as possible the politics of the day. And so far, I think in the last 2 to 3 years, we've seen a much more improved process in South Africa, where there was less of that kind of naked politics and more focus on law and experience of our aspirant judges.
The ones you mentioned in the Western Cape.
Thank you so much, Mbekezeli. I want to ask you a qualitative
Has it affected
question.
in any substantial way the quality of jurisprudence that you're getting from the bench? And has the effect been positive or negative, so that we can learn from it?
Historically, acting judges were appointed from senior lawyers. So this would be people who are experienced, who have sort of spent time in the courts, understand how courts work, they've been steeped in the law, and so they are able to, and they are both prepared substantively and procedurally. And so when they come to serve as acting judges, for them it was a service to the bench. It was a service in trying to uphold the rule of law and ensuring that you have a quality bench. And in fact, one of the rumors that I've heard is that a lot of senior trying to uphold the rule of law and ensuring that you have a quality bench. And in fact, one of the rumors that I've heard is that a lot of senior advocates don't want to be permanent judges because it is you earn more money in private practice than you would as a judge. Even though judges for judicial office, I mentioned earlier that some people have very bad attitudes, very bad mannerisms and ways of dealing with people. So you might be good in terms of your knowledge of the law and knowledge of the procedure, but you might not have the correct judicial temperament, and so you wouldn't be a very good candidate to be an acting judge. So you are impatient, you can't listen to counsel, you interject too many times, you don't allow counsel to make their submissions, and sometimes you just the way you phrase your questions might not be the most respectful way, and the way that judges ethically are bound to conduct themselves in court. And so there are those kinds of apples, and at the same time there have been some acting judges who are not as skilled as one would expect for someone who has 15 years at the bar or 20 years at the bar. So we have seen some really shocking judgments coming out from acting judges, and luckily at this point it's few and far in between, but it's still distressing that someone's case is dealt with in the correct way, and you rely on the appellate process to correct those kinds of things. So I would say it's been a hit and miss. I can't say it has been 100% successful, but overall it has been a good system that we've had. And I mentioned earlier that for some it does prepare them for judicial office, because some advocates assume that because you are in court every day, you can now sit on the bench and adjudicate cases, whereas being a judge is a complete paradigm shift from being a counsel or an advocate. An advocate is partial, right? You take your client's side and you argue it to the best of your ability, whereas as a judge you are obliged to listen to both sides and come to a decision based on the evidence and the law. And so it requires a different kind of mindset, and often some advocates who thought, look, I'm a hotshot lawyer, it's easy to be a judge. Some have actually said, no, it's actually much harder than I thought. But also one of the things that I've heard a lot recently from different advocates who've acted as judges is that it actually benefits your practice as well. Having sat as a judge, especially in a busy court like Johannesburg or Pretoria or any other high court in the country, you now see the kinds of pressures that judges are under. So they don't have time to be reading long-winded argument or court pleadings that really don't get to the heart of the issues. And so when those people who've acted as judges go back to practice, it sharpens their advocacy, it sharpens their ability to be precise, to be brief, to be on point when it comes to the kinds of ways in which you draft your court papers, your pleadings, and how you make arguments in court. So it's been both a benefit for them personally, but it's also been a benefit to the public, who are able to then get their cases heard much sooner than they otherwise would had people not served as acting judges. If we were to wait until judges come back from 3 months of long leave, it really would undermine people's confidence in the system. Not to say that we don't have backlogs, but this project seems to have addressed some of those critical backlogs.
Is that you referenced, a progressive South African constitution after apartheid. Interestingly enough, the Ugandan constitution, or the framers of the Ugandan constitution, were in a similar progressive mindset after our problems in the 70s and the 80s. And you mentioned you mentioned about how judges matter, but perhaps the most important thing about judges is their number, because if you have so few, then you can't resolve disputes quickly. Last year, our justice system spent an extra $15 million on justice, but ended up resolving 17,000 less criminal cases. So the issue I think I would want you perhaps to share with the listeners is, from a case backlog point of view, from a periods of resolution point of view, how have these ad hoc judges assisted the South African struggle for justice, for access to justice, for speed in dispute resolution, and so on? That I think you've mentioned. You've been very elaborate on the benefits to the practitioners and perhaps to the practice, but from a quantitative point of view, I'm interested in seeing what that did.
Yeah, so yes, Uganda and South Africa do share that constitutional history. I think between 1994 and 1996, we were in both countries, we were rewriting our constitutions and trying to craft them in a way that would serve society. And maybe in the last 30 years, we have achieved much, but I don't think we can sit on our laurels and think that we've achieved everything. I think there's still a lot of work to be done, especially in respect of access to justice. So similar to Uganda, it hasn't always been a rosy picture in South Africa. We have about 250 judges who are stationed at the 20 high court centers that I spoke about earlier. And those judges serve the entire 60 million population of South Africa, and unfortunately, because of that number, there have been historically high backlogs, and those backlogs simply are as a result of the courts are in some ways relied upon very heavily in our society, and we are seeing more and more cases that really should be resolved in Parliament. For example, political disputes that should be resolved in Parliament that end up in the courts, and that adds a lot of pressure in our court system. But just to zoom in on the backlogs, which we do have. Currently, the judiciary has a target of a 30% or less criminal backlog. And what that means, firstly, there is no formal definition of a backlog, but when we assess, we as judges meant to assess how the judiciary is performing, we draw on what is called the norms and standards for judicial performance. And these were passed by the Chief Justice in 2014. And what the norms and standards say is that a civil case has to be resolved within a space of 6 months from the time at which it is filed in court. So you from the time at which you file the first papers, there should be all the court papers must be exchanged, and there should be a hearing and a judgment within a 6-month period. And then there's a different requirement for when a judgment must be handed down. So for a judgment in a motion, in what we call an application, the judgment must be handed down 3 months after the hearing, and that's written in the norms and standards. So if there was a court hearing on let's say the 1st of January of any year, the judgment must come out by the 30th of March. And so that is put in the norms and standards. For trials, there is a leeway that is given. I think it's about 6 months for you to deliver a judgment. For criminal cases, a criminal case must be resolved within 9 months. So A plea is entered within 6 months. So or at least a trial happens within 6 months of the plea. So we don't have a formal, proper system that ensures proper adherence to these norms and standards. And this is a concern for us because people are seeing the backlogs in cases grow. So I mentioned earlier that there's no formal definition, but the working definition is based on the norms and standards. So if a criminal case is taking longer than 9 months, it is considered a backlog case. And if a civil case has taken more than 6 months, it is also considered a backlog case, particularly if it is a trial case. It is often considered a backlog within that time period. And so in using those parameters, there is often a very high backlog in the different courts. Unfortunately, the raw numbers are very difficult to find, but from the annual reports that one of our colleagues there mentioned earlier, the backlog, especially when it comes to criminal cases, has generally been 30% or just above, or sometimes it goes below. And so it does seem that the judiciary is meeting its targets to make sure that the criminal cases move much faster than or move according to the norms and standards, I should say. But there are many cases that we do know that, so the 30% unfortunately doesn't tell us the exact number. So 30% could be 500 cases in 1 year, 30% could be 1,500 cases in another year. So we don't have those accurate numbers, but overall we know that there have been times where the backlog has been very high, and that is where the acting judges get appointed. So in 2023, especially the Western Cape High Court and the Cape Bar, they got into a partnership where there was a huge backlog in criminal appeals. So these are people who have either been tried and convicted in the magistrates' courts, and their cases are either on automatic review. So if the case was presided over by magistrates who's less than 7 years experience, it becomes an automatic review to the High Court, or sometimes there will be it would be appeals that it's make themselves available pro bono without payment to adjudicate as acting judges some of these criminal appeals. They were able to bring down these appeals to the point where the project was done away with. I think a lot of the criminal appeals arose out of COVID, and so they were able to bring those down. But we don't in that situation have exact numbers, but we can assume that it has worked because it's now no longer used as much anymore, even though there is still a specific backlog division in the Western Cape High Court. So they do still have a backlog court, but it's now presided over by one permanent judge, and it's no longer using those acting judges. So in some ways we could take by that there is some success in dealing with the backlog using acting judges. But one of the things that we've been critical of, and I'll just close this point here, one of the things that we as judges might have been critical of is this over-reliance on acting judges. It's not normal, it is not acceptable in a proper functioning judiciary to have acting judges being sort of the go-to when it comes to adjudicating cases. We should have a full complement of judges who are able to deal with whatever caseload exists in the courts. And so what we have been saying is that actually spending time on acting judges or even accepting pro bono judges distracts from the real issue of increasing the number of permanent judges that we have in South Africa. So since 2009, there has hardly been an increase in the number of judges, of permanent judges in our courts. So I mentioned that there are about 250 judges serving the entire 60 million population of South Africa. Really fund the judiciary to increase the number of judges, to make sure that we have an adequate supply of judges to meet the growth in the population, the growth in the economy, and the complexity of the cases that come before the courts. Right now, we need more judges who have experience in complex criminal law that involves financial crime. We need judges who understand blockchain and AI and those kinds of new fields of legal expertise. And so we do need to increase the number of judges, and we shouldn't really be looking at acting judges to plug a gap that should properly be filled by a government that is responsible.
Going by your norms and standards. Going by your norms and standards, if we applied your norms and standards to backlog in Uganda, I can say without fear of contradiction that 100% of the cases in Uganda would qualify as backlog in South Africa. And any case that meets your criteria that you've set out, a verdict in a criminal trial within 9 months, civil within weeks, within months, would be prima facie evidence of corruption. Just on the face of it. And that, for me, is the actual crisis we are facing. Because when you're saying that the judiciary should be properly funded, the fact that lawyers coming in from private practice are able to give you those sort of numbers, and you're saying that generally you're at 30%, and when it exceeds that, the bar even comes on board before the government can fund and acts in a pro bono manner to deliver justice. If you look at what we are having here, I know of a case where someone said 15 months into 8 witnesses is record speed. We have people on 5 years on remand, but maybe Mercy will come next. But I like the norms and standards in South Africa, and this is actually the point of Article 142.2, so that we can have the sort of complaints, Benjamin, that you're having, because I can guarantee you that there is not one case, not one, I know of where they would qualify, except of course where on the face of it, where you see that happening, that would be prima facie evidence of corruption. But maybe Mercy, you can add a word or two here.
Yeah. Sorry, I should also add the norms and standards. We are pushing very hard for the
Benjamin that you are having, because I can guarantee you
what the
that
judges
there is not
are pushing back against is that they say
we are pushing very hard for there to be full compliance with them, but what the judges are pushing back against is that they say you can't demand that we deliver judgments within 3 months if you don't provide us with properly funded, properly resourced, and up-to-date libraries. If you don't provide us with researchers, or you don't give us the tools of trade that enable us to write judgments within 3 months. We want to write judgments in 3 months, but you can't deny us resources and then expect us to perform at the optimal level. And so there's a big debate now. I would call it a debate, even though it's like much more tense than that. But there's a big debate about whether these norms and standards actually speak to a reality that exists for a judge in the city, or a judge in a rural area in South Africa. So there's also those kinds of debates.
Benjamin, this is Mercy. I just want to say thank you very much. That conversation honestly aligns with the different conversations we've been having with respect assessment to take work away from them? What's the way that they work together, and how can we borrow that synergy, so that when we maybe push for it to be implemented over here, we have a very good synergy between the appointed mission-based judges and the permanent judges. And I think the other question I also have is, you've mentioned the appointment of mission-based judges. So in South Africa, how does that look? Do you have separate regulations? Do you have guidelines? How is it done so that whoever is the appointing authority has a place to go to when they want to maybe remove somebody or manage how they're doing their work? How is it managed in South Africa? That would really help us to have oversight. Yeah, thank you.
Thank you very much, Mercy. It's an excellent question, and in fact, this is one of the areas where constitution actually is better than the current system that we have in South Africa.
Article 143 of the Uganda Constitution is very clear about the qualifications that you need for appointment.
The Constitution,
Whether in a permanent capacity.
Article 143 of the Uganda Constitution is very clear about the qualifications that you need for appointment as a judicial officer, whether in a capacity or an acting capacity, and that I think is an important guide in how this appointment power is exercised, and actually would help in ensuring that you get very good people to be appointed either permanently or in an acting capacity, in an ad hoc capacity, and I think that this is something that we could borrow in South Africa and implement. So I think you have it good in that respect, and part of the reasons why I think we in South Africa should adopt a similar process is that, and in response to the second part of your question, is that our current system of appointing acting judges, even though I did say that often you would have senior advocates who are appointed as acting judges, and for the most part, all of them are really good people. But where we've seen, sitting where we sit as judges matter, where we've observed the system, is that there are weaknesses. And one of the weaknesses is that each of the 9 judges presidents has their own criteria, have their own criteria for the appointment of acting judges. Some judges president would emphasize that you must have broad experience in the courts. You must have the depth and complexity of your practice must prepare you for appointment as a judge. Other JPs focus on the years of experience. So if you spend time, then I will appoint you. But one of the things that we are really worried about is that because the system is so flexible, it does sort of become open to abuse. You can find a judge president somewhere only appointing advocates who are of a particular race or of a particular class, or who come from a particular bar in terms of the appointment of acting judges. And I mean, human beings are human beings. It's not entirely insulated from patronage, where a judge president would try and curry favor with their local bar by appointing certain popular members of that bar. And so we do have that fear, and we are pushing very hard for there to be a much tighter process for the appointment of acting judges. And in fact, in the last 3-4 years, the Minister of Justice has been working on developing guidelines or criteria for the appointment of acting judges, where I mentioned earlier that the appointment as an acting judge is sort of the first step towards your permanent appointment as a judge in the High Court. And so often the judge president who selects you, and we call it a tap on the shoulder, the judge president will select you by a tap on the shoulder. Usually that sort of lays the path for your permanent appointment. But if you are a mercy who runs their own practice, a complex practice, but you don't necessarily come before the face of the judge president, you might be overlooked for that opportunity. And even if you desired to be permanently appointed, you wouldn't be given that opportunity because they'll say, have you acted as a judge? And so that for us is a fear that we have, and we're pushing for the minister working with the judges to develop clear guidelines, clear criteria that would apply across the board for how you select and appoint acting judges and how you manage them when they are appointed. It shouldn't be that it's a probationary process in the crude sense that we spoke about earlier, and even in the way that it is done in the Kabamba case, where you see it as being a threat to judicial independence. So we do feel that having guidelines would address that problem, and it would also make the process fair for everyone. Everyone would know that the reason why this person was appointed over that person is because this person was more qualified to be appointed as an acting judge or an ad hoc judge. So that takes care of your second question. Regarding your first question about the attitude of the judiciary when it comes to acting judges, fortunately, it has been overwhelmingly positive. In fact, you can go anywhere in the country, any judge president would be delighted to have people make themselves available as acting judges, because it does take care of the work that would be facing the courts. I mentioned earlier that some cases would have backlogs, and so having people willing to come forward to do this work is welcomed. It takes a lot of the pressure of the judges, and they are able to take care of other work. And in fact, in some ways, in Johannesburg and maybe in other courts, usually acting judges will be allocated, I would say, less complex work, and they would take care of that kind of work, or even the backlog. So the cases that would have been backlogged had it not been for the acting judges, and that frees up permanent senior judges to deal with more complex work, because the saying in the judiciary is that the more senior you are and the more experienced you are. Courts in South Africa are generalist courts, so we don't necessarily have a commercial division, an environment decision, administrative law division. Usually, as a judge, you deal with the whole nature of the cases. In one term, which lasts 9 weeks, you can, if you're allocated to civil work, you can deal with administrative law in 1 week. 2 weeks later, you're dealing with an environmental law case. 2 weeks later, you're dealing with a family law case. And that also, I think, helps in making sure that judges are able to deal with all kinds of work, but also it does prepare judges to be able to be skilled enough to handle different kinds of cases. So to answer your question, Mercy, it is often welcomed. Judges in South Africa do welcome the appointment of acting judges, and again, I mentioned it does bring sort of unity and solidarity between the bar and the bench, because the bench does feel that the bar is supportive of the judiciary, and the bar does feel that
I think over the last 1 hour we've ideologically aligned ourselves on the matter of backlog itself and the capacity of ad hoc judges or mission-based judges to deal with it. If I could borrow a word from our ULS president, who is now illegally exiled, we have become doctrinally perpendicular on that matter. But I want us to deal with these bureaucratic parallels that exist. For example, in South Africa, you have judge presidents, an office that's not existent in our judiciary. We have perhaps the principal judge and the chief judge. You did mention that your appointment of ad hoc judges excludes the Judicial Service Commission. The way it's being suggested here should include the Judicial Service Commission. By way of advice, how would you bureaucratically approach the idea of appointing the people that should become ad hoc judges and thereafter removing them from that office?
Uganda Constitution, Article 142, subsection 2, it sort of makes it mandatory that the president has to be involved, the Judicial Service Commission has to be involved, and that does.
Yes, so unfortunately, the Uganda Constitution, Article 142, subsection 2, it sort of makes it mandatory that the president has to be involved, the Judicial Service Commission has to be involved, and that does sort of limit the kind of flexibility that we in South Africa have when it comes to the appointment of acting judges. And that unfortunately adds this bureaucratic layer to it. And so what I would think as advice to how you would get around it in Uganda is to try and have an open call. Well, firstly, you must have clear criteria for selection, and what do they? I think they call them resident judges in Uganda, or the senior judges would have the discretion to be implementing this process. And how it should work is that you have to have written criteria. So who would be a good person to be appointed as a mission-based judge? What is the mission? Sometimes you would need to define it, to say at one point it might be a mission to deal with a criminal backlog, or it might be a mission to deal with environmental law cases where there's a backlog there, or in the commercial division of the court in Uganda. So you will need to have that upfront, and that would assist in sort of making sure that the process is clear, is fair, it's transparent for everyone. And then secondly, how you implement it, I think, is through an open call. So practitioners should be able to say, I'm firstly raising my hand to volunteer for this process, or I'm willing to be appointed, and these are my dates of availability. This is when I'm willing to give up my practice or stop practice and serve in the courts, because that is also a big issue in South Africa, where you might find that firstly, the requirement in South Africa is that when you are an acting judge, you are not allowed to interact with your practice at all. And so for that period you're an acting judge, you're supposed to create a Chinese wall between yourself and your practice, because you are now a judicial officer and your judicial independence requires only for you to be focused on your judicial work and not on your practice. So how you get around that issue is to allow people to give you the times and dates in which they are available. Often, I don't think it's a good idea for someone to serve as an acting judge for 1 week or even 2 weeks. I think maybe 3 weeks to longer is the best. And so people should be able to put forward the times in which they are available, and the principal judge should be able to plot in their calendar where certain people can be placed and where you'll be able to cover the period. Also, the thing about the mission, you have to sort of have a time period for when this mission will be done. So if we are doing the criminal backlog in a region of Kampala, we should be able to say, give or take, if we have a maximum of 20 ad hoc judges or mission-based judges coming on, we are likely to finish this within this period, given the complexities of a trial and the nature of the evidence that needs to be heard. So you need to, the principal judge needs to have a proper grasp of the kinds of cases that are sitting as backlogs in their courts, and they need to plot a time period where we'll be able to deal with that backlog. That is important for two reasons. Number one, it gives people a realistic sense of, if I make a contribution, this is where my contribution will go, and it incentivizes people to actually put shoulder to the wheel and achieve the outcomes of the mission. So it's good in that respect. But the second respect is that you don't want something that is unending, because clearly the problem is not that you have a temporary backlog, it's a permanent backlog, and your response should be a much more permanent solution and not just a temporary solution where you're appointing people for an ad hoc period. And so I think that is another consideration in how you design the system. And so if you have people who are willing to put themselves forward and they indicate the time period, then you as the principal judge, you will be sitting with a pool of candidates and they would have indicated the time that they are available. And so you are then able to, and you have a criteria in place for how you assess those people for their suitability. Then you can design a system where you send the appointments in batches to the Judicial Service Commission and for confirmation by the President. So the principal judge would send a list of, let's say, 20 potential acting judges who would serve for a period of 3 months or whatever period is necessary. Let's say 3 months for argument's sake. Those people would serve for 3 months, and that's how long the appointments would be. So you'd send that list to the JSC. The JSC can scrutinize that list through looking through these people's resumes or CVs, and then make the recommendation to the president for appointments, and then these people can hit the ground running. But you need to do it obviously ahead. If you're appointing people for 3 months and it's already March 2025, that means the 3 months will run from June to September of 2025. You can't do it today and expect that people will start working next week, because that just is unrealistic. People can't manage their affairs in that respect. In South Africa, why it's been good to exclude the JSC and why we actually don't want the JSC to be involved in the appointment of acting judges is that the JSC only sits twice a year. I mentioned earlier 23 members. So you would require 23 people to sit and come to a decision, and it's not practical. And in the time period that you want the decision to be made. If you're saying you're appointing people from June, then it will, by June, you still would not have completed the recruitment process. But the other issue is that in South Africa, the recruitment process involves an interview where it is done formally before the commissioners, the 23 commissioners and the JSC. I don't think that should be the process in Uganda. The interviews should be done ideally by the principal judge sitting in Kampala, who says, these are the candidates that have made themselves available. If I have any questions beyond what is written on their resumes, I can call them in and just quickly interview them and then recommend them to the JSC, who would recommend to the president, and then the appointment is made. So I think that is one way of handling it in terms of the volume, the numbers, and also managing expectations, because like I said earlier, you do want people to let go of their practice for the period in which they are acting as judges. So you do want to give them enough time for them to wind up their affairs. I think it's a fantastic suggestion you've made.
Although the particular circumstances of Uganda, I think we would be interested in the bar being independent and not lawyers trying to suck up to a particular judicial officer to get the appointment, and of course the circumstances of our judicial service commissions are different. I would actually take everything you've said except the principal judge, who I respect very much, and I would say that let people make the applications. As you said, they come up, we have written regulations, we have the requirements that will be required, and then the Judicial Service Commission does the advice. What Article 142.2 removes from the Constitution, what the Constitution removes in Article 142.2 is the requirement for parliamentary approval. So where I think the JSC, and I think we've seen a lot of the JSC interviews in South Africa. I think at one time Malema used to sit on it, and there are those famous questions between him and different judges. We don't have the same kind of political control of the JSC, because in South Africa you are correcting the historic injustice of an 100% white judiciary, and you needed some political interventions here. But I think the idea that you've put out, that we should have ad hoc mission-based judges coming from the bar but being appointed, I certainly would also, I'm quite impressed that many South African lawyers do this on a pro bono basis. that you become a judge on a pro bono basis. I think here in Uganda we would also not be encouraging anyone to sit in a judicial office on a pro bono basis for reasons I can't necessarily say. But maybe I can hand over to Alfred and he builds the point.
It's actually reasons that are shared. We
On a pro bono basis
don't support pro bono judges. I think one of the guarantors of judicial independence is financial security.
It's actually reasons
so
that are shared. We as Judges Matter don't support pro bono judges. I think one of the guarantors of judicial independence is financial security. So if you've already said someone must give up their practice for 3 months, then it is you are really putting them at huge risk of impinging on their judicial independence if you also don't pay them. And so we believe that everyone who serves as a judicial officer in South Africa must be paid. It shouldn't be that you are doing pro bono judges. I mean, a pro bono, you're acting as a pro bono judge. I mean, it's different if you're doing like what was done in the Western Cape, where people come in every Friday to deal with a criminal appeal backlog. That is different. Then that kind of thing can be pro bono. But if you're asking someone to serve for much longer than a day, then you should pay them. You can't do pro bono. But also, one of the things that we've seen is that the only people who can actually afford to be pro bono judges are often white male advocates who do have the resources, the money to spend 3 months and not get a single cent coming in. But for most of the practitioners in South Africa, they can't afford that kind of expense, and so I think it's a disincentive to get the kind of diversity that you need for a judiciary for you not to pay people. So we are not in support of pro bono judges, even though we commit desire of people to serve their country for free.
I have one question from the comment section, which I believe is part from your previous submissions. One is asking, why shouldn't appeals on verdicts of acting judges be handled by experienced judges? That's one of the questions, and then anyone who has questions to us can send a microphone to speak. Mr. Benjamin, I think you can first answer that, then we could get a question from Sherengat Esther, then others who have questions can as well send. Maybe to add on the one of why shouldn't appeals on verdicts of acting judges be handled by experienced judges. There was also another question of, for a long time now, the business of the court in Uganda has required that at least you appoint mission-based judges. In your previous submission, you briefly hinted on why it is quite hard for Uganda to appoint local judges or mission-based judges. But just on a broader view from your research, why do you think Uganda struggled so much to effectively implement the system of ad hoc judges or mission-based judges, despite having clear provisions in place since 1995? Thank you. Why do you think Uganda struggled so much to effectively implement the system of ad hoc judges, despite having clear provisions in place since 1995? Thank you.
Thank you very much. I think I wasn't on the first question on why shouldn't appeals or verdicts on appeals be handled by experienced judges. I think I maybe didn't explain properly. So the appeals that I spoke about earlier, those are appeals that come from the lower courts. They come from the district courts, and they come to the high court, and the verdicts are done by magistrates, and then they appeal to the high court, where sometimes it is adjudicated by an acting judge. But I should also add that an acting judge, when they are dealing with appeals from the magistrates court, they don't sit alone. Usually appeals are dealt, an acting judge is paired with a permanent judge to adjudicate on the appeal, and those appeals are criminal appeals. So when someone is appealing a verdict, a conviction or a sentence, they appeal to the High Court, and the High Court, there will be an acting judge sitting with a permanent judge to adjudicate that appeal. So that is the practice that is done generally. It's never just an acting judge sitting alone. But overall, even in cases where an acting judge is sitting alone, because in some cases they do sit alone when it comes to civil cases where the High Court is the court of first instance. The acting judge, they will sit alone and they will adjudicate the case. Appeals of those cases go to a 2 or a 3 judge bench that is made up of permanent experienced judges. So there is a quality control system that ensures that acting judges, their judgments are sound in law when they are adjudicating. So I mean, but you in an ideal world, you don't want for there to be an appeal, because that means a litigant is having to pay more money for them to have a correction made. And so that is the how the quality control process works. And then the question on why Uganda has taken so long to adopt this practice. To be quite honest, I don't know. That is my answer. I don't know. But I have a suspicion about why, and this suspicion probably is completely off the mark. But when I read some of the judgments from the Uganda court, it does seem that it's not a culture that exists within the legal community in Uganda, even though, ironically, Uganda and South Africa do share this English common law legal heritage, where in the UK, for example, they do have deputy judges or recorders who are practitioners who serve as ad hoc judges in the courts in the UK. And so that's where tradition in South Africa comes from. And I assumed that it's the same in Uganda, but clearly I'm learning that it is not. And so it might be more of a culture problem and less so of a function problem. It's just that it's not familiar. And some of the arguments against it are not entirely illegitimate. They can't really be dismissed offhand, where you find ad hoc judges, they might not be as independent as permanent judges, because one of the guarantors of judicial independence is security of tenure. So when someone is appointed, they must know that they may not be fired based on the kind of verdicts that they give or the kind of judgments that they give. And so when you have this system of acting appointments, you sort of do you make the system vulnerable to questions of the threats to or the risks to judicial independence just by not guaranteeing the security of tenure. And this is something that has sort of been thought about in South Africa, in the sense that the ideal situation, and which is what I think Uganda should follow, is that you should be appointed for a time-bound period. You should be appointed for 3 months. And if you're appointed for 3 months or 6 months, it can't be that in the second month your appointment is terminated, because that would be an attack on judicial independence and would infringe on this guarantor of security of tenure, or this guarantee of security of tenure rather. And so I do think that there is a question to be asked about how this process is managed, but I do think from knowing the circumstances that exist in Uganda and the backlogs that the Ugandan courts are facing, and how that is actually a serious threat to the legitimacy of the judiciary, I think Uganda should really be considering this appointment of mission-based judges or ad hoc judges or acting judges, as we call them in South Africa. Because, I mean, if people don't have any faith that their case will be heard in the next 5 years, then why not just beat up the person? Why do you need a court order to evict them from your commercial premises? Why don't you just bring a group of bouncers and beat someone up? It does undermine the rule of law. It does undermine the legitimacy of the judiciary, and it's an injustice. I mean, it's a complete injustice if you have a business and you have to wait 5 years before you can get your debts to your business paid. You won't even have a business in 5 years if your whole commercial endeavor is tied up in litigation. So I do think that it is something that should
fast running out of time. I want to thank you, Benjamin. I'll allow everyone to say something, but I just want to say on the point you've just made, a serious threat to the legitimacy of justice. Backlog is a serious threat to the legitimacy of justice. And you said, why should you go to court if you can just beat up the guy? Some people who can't beat you up are resorting to spiritual means, but there's a lot of spiritual backlog as well as a result of some of these challenges. And I think the point really that you really put your hand on it, Benjamin, it's that the legitimacy of justice means that disputes brought must be resolved. And I'm really going to start advocating for us to adopt the South African standard, the desire to say that within 9 months from a verdict, from a plea, you should have a verdict. Within 6 months from the filing of a civil case, you should have a judgment. Those standards, I can tell you, would be absolutely incredible, but they are they'll definitely happen after the mission-based judges have come in, completed the mission of clearing the backlog that their lordships have, and then I'm sure that their lordships will be able to push it on. So I think it's been a fascinating conversation. I don't know, Rusho, what you think. I think it's been a fascinating conversation. I want to thank Benjamin, and maybe we'll just take a word from everyone. Rusho, then Alfred, Mercy, and then Raymond, and then we'll hear from Benjamin again and wind it up.
Thanks, Elison and Benjamin and my fellow hosts. I think it's the interesting thing for me from this conversation is how much from a Ugandan perspective we underestimate the job of the backlog. Like we had said, last year government spent an extra $15 million on justice, and that only shifted the needle 0.1%. Now, the conversation I'm hearing from Benjamin is that even when the South African system has exhausted all the additional options available, including ad hoc judges, they have moved the needle much further. There is still progress to be made, but they have moved the needle much further. And certainly for any of the practitioners that were listening to the conversation, if you had to choose what jurisdiction to practice in, I'm sure you'd prefer the South African one over the Ugandan one. But perhaps for me, the other interesting thing that came out of Benjamin's conversation with all of us here is an old saying, which I'm sure there must be an equivalent in South Africa somewhere, that says that people cannot be despising the army and you propose that they should remove adults. You get the means which are available to the Ugandan justice system to meet the justice demand are not sufficient. So we don't have...
Thank you, Benjamin. Enough has been said, and thank you so much, Benjamin, for sharing with us how South Africa has used acting judges to supplement the judicial system and enable access to justice. I can't imagine having a judgment in 6 months after failing a suit. Yet, after failing a suit 6 months, I'll be having adjournments for 6 months. But if I could suit yet, after failing a suit 6 months, I'll be having adjournments for 6 months. But if I could have a judgment in 6 months instead of a normal adjournment, I'd be very grateful. Thank you so much for sharing your experience with us. And thank you for everyone who has tuned in today. The President, Law Society, Mr. Isaac Semakade, I saw the interim secretary still on call. Thank you for sparing your time to join us today. We see you next week on Wednesday on the aspect of mission-based judges. No one can stop reggae. Okay.
Thank you so much, Mbekezeli. I join many other people, of course, to also thank you for sparing of your time and for being such a knowledgeable host and guest for us today. I don't take it lightly. Like I said, I will borrow the words of wise but now exiled UNS president. We are now doctrinally on the matter of mission-based judges, and more particularly in their role in addressing case backlog. Elison did mention earlier 45 trillion shillings of Uganda's money is stuck in the court systems, and there's no other way to get it out other than to listen to the cases that are therein. So we are waiting very impatiently to have this election for JSC. We're waiting more impatiently to have mission-based judges, and I hope that this succeeds. Thank you so much also to the people that have been listening to us for close to 2 hours now. We're delighted that we could make your company for the evening. Have yourselves a good evening.
Mercy?
Much also to the people that have been listening to us.
I can't hear Mercy. Maybe
Mercy could be having network challenges. Keep it.
I can't hear Mercy. I don't know what's happened to her microphone. But I think I don't think there are any more requests. I see the president of the Law Society is still on. It would be good to hear him greeting his people. But maybe at the meantime, maybe Benjamin, you could just give us your really your parting thoughts. But before you even give us your parting thoughts, really allow me to thank you so much for really taking the time out to explain to us why judges matter, to explain to us how the work you're doing in South Africa, and more fundamentally to really kind of expound this idea with us and to help us walk. You know, they say that when you walk a journey alone, you may walk quickly, but when you walk it together, you will go far. And I think with you, you've taken us far. You've shown us what is possible. You've shown us what is happening. You've shown us the challenges and pitfalls of what is being suggested. You've shown us the route that we can pass, and I think it's been a particularly rich discussion. There is nothing richer than sharing ideas. To quote a book, they say somewhere that it is like when brethren meet together, it is like what? Rushongoza is a part-time pastor. So he says,
the Lord laughed at the accusation.
He says it is like oil flowing down Aaron's beard. So thank you so much, Benjamin, and Rushongoza is a part-time pastor. So he says it is like oil flowing. Yeah, so thank you so much, Benjamin.
Yes, I'll just be brief, and I would also like to extend a really humble and grateful word of thank you for the invitation. I always get excited to speak to brothers and sisters from all over the continent. I don't think that we are having enough of these kinds of conversations wherever we are sitting on the African continent. And so it's, for me, it's a complete honor to join you tonight and to actually have a little bit of a taste of what's happening in Uganda. I've really enjoyed, thoroughly so, to learn about what is happening in Uganda and read about the legal developments there. I'm really excited also to see so much energy and for the president of the Law Society of Uganda to be present with us throughout these 2 hours as I'm droning on and on. It's an honor as well, and I hope that all the members of the Uganda Law Society and every lawyer in Uganda does see the work that they do is valuable to us who are sitting and watching the developments there. I mean, the independence of the legal
that the people of Uganda can enjoy a taste of
Benjamin, I can assure you we will not stop here. Nobody can stop reggae. But maybe just before you go, I'm seeing there's a request for a question, but I also wanted to recognize, apart from the President of the Law Society, the Honorable Mr. Justice Ezekiel Mohanguzi, Justice of the Supreme Court of Uganda, retired Justice of the Supreme Court of Uganda. I think had served at all levels of the Ugandan judiciary. He has also been here for 2 hours. I don't know if his lordship also wants to. But I think the people who have come to listen to you, Benjamin, show you the level of seriousness within which this particular issue is taken. There's a Dr. Nahalana Dube from I think is from Zimbabwe, and maybe Doctor, if you could just speak for just a minute before we could wind up the space.
It's been a good session so far.
Maybe Doctor, if you could just speak for just a minute before we could wind up the space. So,
hello everyone. It's been a good session so far. What I've caught had connectivity problems. But I just want to say, as a Pan-Africanist, it's heartening to see this intra-continental connection. Uganda is a country. I'm a Zimbabwean. Uganda is a country I admire very much. It's a country I hope to visit one day, and it's good to hear of all the latest developments that are happening in your legal
the Honorable Dr. Elison Karuhanga. I have also seen the Honorable Proscovia Salam Musumba. I think they were both framers of the Ugandan Constitution in 1995. They were both framers of the Ugandan Constitution in 1995. And so I think, Benjamin, you've brought a quality to this conversation, and so many people have come to listen. But I also agree with the previous speaker that this intra-African conversation is powerful and important. And in that regard, I think it's been a fantastic conversation. Mercy, maybe you will, as the you'll maybe Mercy. I see Mercy is still on. Let's allow Mercy, Benjamin, to have the last word, and then I will have the final word. Very clearly.
Okay, thank you very much. Benjamin, I just really want to.
Let's allow Mercy, Benjamin, to have the last word, and then I will have the final word.
Elison, you can hear me?
Very clearly.
Okay, thank you very much. Benjamin, I just really want to express my gratitude. Your presence on this particular space was very rewarding, but also very timely. I think it summed up all our previous discussions and placed everything into perspective for anyone who has been following the spaces. I think the issue of case backlog has been made even clearer from a context of another country in Africa, but also even the implementation of this idea of mission-based judges. I think my biggest takeaway is that, as we've already been emphasizing, justice is not in a building, it's a service, and it should be given in the most creative ways, and one of them being the appointment of mission-based judges. I take it from our discussion today that we only have to push to have our representative on the Judicial Service Commission to make sure that we have this particular thing implemented. Thank you very much, Benjamin. I believe we're going to be following your work, and we're going to benefit more from it after listening.
I think everyone can hear the beats and the drums from corner to corner, from Zimbabwe to. I think Benjamin in Mbekezeli means what? It means is it Kunosa? Is it Ndebele? Who I know in Ndebele it is who brings joy. It is Zulu. And is it Kunosa? Is it Ndebele? Who Mbekezeli it is who brings joy.
It is Zulu, and it means, yes, it means one who perseveres. Mbekezeli. So I appreciate all these wonderful words. It's one Africa. We are all one Africa. Dr. Dube, I'm hoping we would one day join our colleagues in Uganda in the Pearl of Africa. We sit and have fun along Lake Victoria. So we look forward to that.
I think Dr. Dube from...
Definitely not.
Sorry, Dr. Dube, you are more than invited, and in Uganda we'll have a namesake of yours who told us that nobody can stop reggae. But allow me, everyone, to just thank whoever's joined us. And as we always sign out, we are signing out right now. And from me, from my friends who have been with me here today, and from everybody from coast to coast and around the world who is listening to us, good morning, good afternoon, good evening, and good night.
None is crying out for justice. Everyone is crying out